Someplace. Agree. Mm. What, am I the only one here?
Well, I'm here. Yes.
Everybody else.
829.
Looks like upstairs gonna join me.
I don't know.
Nobody loves me.
I don't know. Usually, Ginger's here, but I think she had a doctor's appointment this morning, so I don't think she's gonna be here.
That's what I just left. I'm like, physical therapy guy.
So you're all set, you're in, everything's good? Oh, yeah.
I guess
You're
I am.
good, yeah,
Now,
yeah.
what are we waiting for her? The,
Mhm.
what's her name? Okay.
No, it just shows you everybody that's joining. And you could, if you wanna put, so they can see you, you can put the camera on. I didn't.
It is on.
Oh, okay, okay.
More pictures, the better.
Good afternoon, everyone. See if folks, well, maybe we'll give them another minute to join. I'm looking for Kristin.
Hi, Wayne.
Yes.
Hey, Jacob's trying to get in, but he says he can't get in the meeting. Do you see him on there trying to join?
No.
You don't see? Okay, go try your laptop then, Jake.
Yeah, Kristin just joined, so people are able to join. So yeah, maybe just try another avenue.
Okay. All right, he'll try his laptop. Thanks.
Okay, yeah. We'll give him just a second to join, and then we can get going. So.
Good morning.
Good morning.
You still got people coming?
Yeah, we got one that's trying to get in, so we'll give him a second to join. So.
Okay.
Hi, Kristen.
So, good morning. How are you?
Good. Yourself?
Good. Good, good. I have one of your agents in my office. Maybe she needs to join us. Let me
Oh,
see.
Holly, sure. It'd be nice.
Yeah, hold on one
You
second.
can tell us what to do or what we need to do.
Right. Well, I think we'll get going here. I haven't seen Jacob yet, but he could just be under something. But a few other folks joined, so I'm glad we did wait a few minutes. So super happy to have Kristin here today with us. I know we all have attorneys of choice, and we've all worked with someone and then just kind of trust them. So Kristen's been my go-to since the very first day I started real estate. So 15 years ago, actually over almost 16 years ago. So when she was just a paralegal with Chuck. But anyway, so I've always trusted her and just thought she'd be great to just hop on. Just kind of start with the sales contract. I don't want to say line by line, but I can guarantee you, for me, there's sections of this contract that I don't know what they mean. I don't want to say I don't know what they mean, but no one's really ever said, put this on this line, this is what this paragraph says, and this is what the line is there for. Some I leave blank. So I'd love to start with the sales contract, but then really anything that you have, Kristen, that you see every day, that will help us write sales contracts. It'll just kind of help us, better prepare for what you do. And I say you, just attorneys in general. And then we'll open it up to a Q&A. So anybody that has absolutely anything, sales contract, just attorneys in general, just remember, when we ask a question, even though I don't want to say even though we know the answer, like you're going to help a lot of folks out that might not ask a question. So even if you just kind of have some stuff that we can chat about when we get to that Q&A, we know we have some new folks, new agents with us and things like that. Questions in just general chat can help. So Kristen, I'm going to just pause for a minute and let you chat, and then we can maybe start with a sales contract.
Thank you. First of all, thanks for having me. Second of all, I don't have a black eye. I traveled this past week and have like a sty or something happen in my eye. So forgive me for looking like a slugger. As far as the contract goes, it's interesting of late because we're getting contracts from all over the place. I think you guys are probably just as well aware as we are that we have players coming in from Erie County, Cat County, all over the place. So we're going to see some different contracts. Chautauqua County, I think the first thing to be aware of is that Chautauqua County is the only county in New York State that does not have a attorney review period. It's not just a given. If you want an attorney review period, it has to be written into the contract. And I don't think that's a bad idea, especially if you have any terms that are kind of outside of what we address here. The Chautauqua County contract is fairly simple, which is why we have the additional riders, as opposed to, like, I'm sure lots of you have seen the Erie County contracts, like 16 pages long or something like that. And even kind of fleshing out what the terms are in there can get a little difficult. Chautauqua County's is a lot more direct, but again, if we get into anything that's outside of, the standard residential single family residence, you'll want to start really modifying it to the specific instance you have going there. And if you have any questions about how something should be written, it would either be advantageous to talk to the attorney for your client prior to, or, include on a standard rider that attorney review period, because that kind of covers your client, it covers you, gives us the opportunity to enter the conversation before it becomes a problem. Because when our Chautauqua County contracts are signed, if there is not an inclusion of the review period, they are binding, all parties. So that being said, the contract itself, honestly, it's fairly simple, and the stuff you don't know about 16 years, that's crazy, time flies, but more than likely it's because it's not going to pertain to very much you do, most specifically at the top of page 2 with regard to foreign entities. So that being said, the more information that you fill out on these contracts, the better prepared we are to get the ball rolling. Sometimes our clients call and say, hey, I'm buying a house, I want you to work with us. I'm selling a house. I want you to work with us. Other times we're getting a dot loop and we're off to the races, right? So the more information provided as far as addresses, email addresses, telephone numbers, I- was there something? Okay. I often receive a little like introductory paragraph in that note section from realtors when I get a dot loop that'll say, hey, you're working with the seller. This is the best way to reach them. You've dealt with them before. You haven't dealt with them before. Whatever the case may be, I'm dropping the search off, you know, and they just kind of give me a summation there with any additional contact information. So, you know, paragraph 1, seller info. It is relevant to know that when you're listing the seller to make an offer, going off of the tax record is going to be your best bet. If it is an estate and you know it's an estate, listing it accordingly is going to give us a heads up to make sure that somebody's been appointed through the court. So once someone is deceased and you know it's being sold as a part of you know, their passing, it's very relevant to know immediately. My question is, who's the estate attorney and has anybody been appointed through surrogates court, which is like a whole nother, you know, area of law. And if there's any questions pertaining to that, please feel free to ask. 2, buyer, if this is your client, please give me as much information here as possible. Their current addresses is often necessary for us. Immediately when I get a contract in on the buyer side, well, either side, honestly, we send a contact letter out, kind of giving them an idea of what comes next or what we need. And then it also lists all my contact information. So it's a really good, you know, initial point of contact. So if their current and proper address is there, it's helpful to us. Telephone number for obvious reasons. Paragraph 3, what I look at here, a lot of times the town or the city or the village is listed incorrectly, and that just has to do with the layers of government in New York State and the fact that Bemis Point is a village, but it's in the town of Ellery, you know, and like knowing this kind of comes over time. But what I'm really looking for here for me is how many units are there? Is it a single family residence where, you know, seller is moving out, buyer is moving in? Great. Is it a multi-family? Is it vacant? Is it 2 units? Is it 4 units? Like that's what I'm looking to extract from that paragraph. And when I write contracts myself, I include the number of units and the size of the lot. The reason I say that, the size of the lot, is because often people won't know that they have 2 parcels. So if it's 100 by 110 listed on there as the description, as the briefly described, but I pull the tax parcel that's listed below and it's a 50 by 110, then I'll know that I should probably be looking for another lot. Although I always look at the surrounding and contiguous parcels as well. Street or road address, fairly self-explanatory. Although around here we have lots of odd street numbers, so that if you need us to flesh that out at any point, the assessor and 911 and all, they lay over top of each other and not always seamlessly. So if we ever need to help with that, just let us know. Tax ID, as previously explained, there it's just helpful to make sure we have them all. But we do check behind you. And those changes are important because I may look and see that, you know, you're selling like a house on Thayer, which has an additional contiguous lot, but they're retaining that, right? So clarifying that there is important. Previous deed recording data, that has to do with how if you're the seller's agent, how your client got title. If you don't have it, that's fine. It is listed on the Chautauqua County website under the history portion of it, owner history. It will tell you the recording information. The contract's a little bit erroneous on this because it's stating Liber and Page, which is the way that our public record was in yesteryear. Now it is instrument number. But either way, if you put recording information in there, great. If you don't, it's not really a disadvantage on the contract because we pull those ourselves. Purchase price, obviously full consideration, the deposit, whose escrow account it's in, and then the further sum due and how that'll be paid. Only thing really to say there is I think it's worth understanding what that deposit stands for. The way that it is kind of, I don't know if it's taught to us, understood between us, bar rules, either way. This is the best option for liquidated damages. If for some reason parties aren't going through with the transaction, this is the amount that first gets us all out of it and the house listed again and the buyer out of any litigation. You know, they make a $100 deposit, $5,000 deposit, $150,000 deposit. If the contract doesn't go forward and everybody agrees, then that's the amount that we can get away from it for. But it doesn't always work that way. They don't have to release anybody from the contract because they're willing to forfeit the deposit. And where and who has it is important because I hope that you guys haven't experienced it, but you certainly can end up with a situation where you have a deposit in your escrow account for an extended period of time until the parties come to some resolution, which could either be through litigation for breach of contract or litigation in small claims in order to get that released. This is also where at least the initial, letting us know that the seller is going to hold any kind of paper, or there's a lease back or if there's anything that we need to look at here that is part of the consideration, part of what makes up the full price. This is a great place to at least start the conversation, and then a rider is probably best. Seller's concession. Some banks are real picky about that, and specific financing has different parameters for what's allowed there. I'm not sure how much you want me to go into that, but conventional financing versus FHA, VA, government insured financing have different limitations there. 3% and 6% of the total purchase price, respectively. If it's a cash deal, it's just a straight credit. 5, just the mortgage contingency. Ultimately, the only thing I really look too closely at here is if it's specific to government insured, because that's going to trigger some additional obligations on the part of the seller. And outside of that, it is the date. As you guys are well aware, that if we go past the mortgage commitment date, we get into a place where buyer or seller could start looking to declare, or seller can look to declare time is the essence. So that the date there is most specifically important, along with if there is any financing outside of just conventional. That's where you want to have that conversation. If you're a buyer's agent, if you're applying for a mortgage, do you know what kind? Because if they don't include FHA or they don't include VA and the appraisal comes back with repairs required, there's no obligation on the part of the seller to meet that, and it hasn't waived your client's obligations under the contract as a buyer. I don't know how I did with that, but that was my best. The disclosure, those boxes should only be checked in the event that you already have the disclosures, that they're attached to the offer. If you don't have the disclosures yet and you're just making the offer, just leave those all blank. Lead-based paint, obviously, real property condition disclosure statement. Hopefully, if it's listed, that's available for you to look at. And utilities. There's a presumption that there would be functioning utilities when you look at the property. Let's see, 7, rental security deposits, everything being prorated as of the closing date. We usually strike 8A, which is 8B is what lets us prorate per the bar rules, which is just as of the closing date. 10 taxes levied prior to the closing date at 8A is just, it's kind of redundant. But rentals, I think it's important to understand that the rules of the Bar Association say that rent is prorated as of the day of closing, regardless of if it's been collected. That's very important to your sellers, especially if rent is a hefty sum, because if they haven't collected rent on closing, we still prorate like it's paid, and it's their obligation to collect post-closing. So that one can come up and bite. We've got a big one going on right now that, you know, it's a pretty big swing in rents. So we try to do investment properties on the first and tell our new buyers to have, you know, that intro letter set and to the tenants so that they know where they're supposed to be paying that rent on the first. But that one we can, I think it's probably a good area to discuss further. We have a lot of rental property around here. Security deposits are not prorated. They are a straight credit to the purchaser. 9, all assessments for special services and improvements. I only know a couple of these as far as like some of the new developments that have connected water or sewer to BPU that are outside of the city. Sometimes there's an assessment with regard to that. I haven't come into anything else, but basically this is an assessment by the utility companies that then is levied against the taxes. We've had a couple over my 20 years that, you know, we have to look at the improvement and if the entirety of it has been recognized by the seller and if it needs to be paid off. Some of them that fall under this paragraph that aren't local improvements or public utilities would be solar panels. We've had some of those come up where the solar panels in there are there already and there's a contract of some sort. So that's just, it's not necessarily an assessment the same way, but it is something to consider. If there's a solar panel contract, that needs to be fleshed out a bit as far as who gets what on the remainder of it. 10 is just the assessment of closing fees, you know, the transfer tax, and TP 584 is the sellers and the RP is the buyer's expense. This is a great place where if a buyer is making an offer to pay the seller's closing costs, this paragraph would be amended accordingly. You know, all costs to be borne by a purchaser. Otherwise, they'll be assessed per the rules. 11 is our most verbose paragraph. And ultimately, it's just saying that according to bar rules, we've got a 50-year search. Good and marketable title is its own thing that needs to be defined and understood, which means that, you know, there are things that are not marketable, like a tax deed is considered non-marketable, and we have to insure over that. There are a couple other instances that title insurance would be triggered in this paragraph, and I'm happy to answer questions about that. The title search is traditionally a seller's expense, but it's not always, and I'm sure you guys are experiencing lots of reassignment of costs between parties right now. I feel like that's been going on for some time, but this is the paragraph where title and survey would be addressed specifically on that. In the event that they can't provide marketable title, or then we would insure over it, and not everything can be insured over. Happy to answer any questions on that. Surveys, we tried to clarify this previously with our checkboxes, and then we ran into the seller's affidavit. I think we've as a collective practice around here, I think we've come up with some acceptable language as far as, you know, seller will provide existing survey with affidavit of no change if available. As a buyer's agent, I would be more focused on this paragraph with regard to the survey based on financing. Your buyer may not be real concerned about a survey unless they're looking to improve and make sure that, you know, they have the parameters of the lot for whether it be a fence or they want to do an addition or something like that. This is a good place to absorb it by the seller. But also, like Lakeshore Savings Bank always requires a survey. So if you know that you're working with a buyer that's working with Lakeshore, make sure to ask for a seller survey, or let the buyer know that they're gonna have to get their own, and they run about $750 for a standard city lot. Cash deals, have them, don't have them. I like to get them for my buyers mostly because, as you guys are aware, when offers to buy come in, they usually have a request for survey. And so then we have one on hand. And between the buyer's attorney and I, we could talk about if we're providing an affidavit or an update. There is a difference. And title insurance has some additional limitations with regard to using prior surveys. So again, anything like that you have a question on, I'm happy to answer. 12. Okay, this is where, I don't know if you guys know or not, but if there's anything found in the title that wasn't disclosed right here under paragraph 12, we can terminate the contract for the buyer. This is a great out. No, that doesn't sound great, but that's what it is. So whether it be a shared driveway, an easement, a shared well, anything that is a title question that's outside the standard, like standard conveyances, this is where it should be listed. As a buyer, you can't put it in your offer. You wouldn't be aware of it. But as a seller's agent, this is where you cover your client as far as, the shared driveways are big. We've got shared garages around here, but this would be a title exception. There's got to be a shared driveway agreement. The right of ways, especially when you're down at the lake, making sure that if you have lakefront property and someone's got a right of way for lake access, that would be disclosed. Some people don't want other people crossing their property, and that would be an easy out as far as it wasn't disclosed under paragraph 12. 13. Oh, this is all the extra stuff, right? So if they're getting the fridge, things of that nature. Obviously, banks often take exception to this paragraph. If there's additional personal property, sometimes we put it on an addendum with zero consideration or additional consideration. But this is, if they're keeping the kitchen table, this is where it would be listed. I think we almost always use an addendum. Sometimes I see a fridge come in on there. 14, this is just where you're invoking your riders. Water sewer is very common, and we can go over that because that's important. Standard rider, anything you need to adjust on this contract. This is also where I would suggest putting in that attorney review period. We also have riders for private financing and personal property and any other rider that you need to include, but obviously it doesn't have to be limited to 4. 15 is the one that has to do with the foreign entity. If you have a foreign entity that is selling, I would go ahead and automatically put in that 3-day attorney review period so that anything pertaining to the IRS and foreign entity selling can be handled by the attorneys. Let's see, 16, possession, that's where your post-closing and occupancy or early entry indication could be there, but it can also be on a rider. Otherwise, we're assuming that it's going to, possession is going to transfer on the recording of the deed. It's important to understand that this contract merges with the deed. So we can't put conditions in the contract that are supposed to survive closing unless we specifically state so. Otherwise, the deed and the contract merge on closing. 17 is just the closing date. This is what we're targeting. I try to always hit them, but obviously without a declaration of time is of the essence, it's just a target. So communicating with us as attorneys as far as what expectations are on both sides, or what kind of drop dead dates are. A lot of times this comes about at the end of the year, holidays and school registration time. 18, obviously, this is on the buyer side, just the time frame by which the seller has to accept the offer. I don't know why there's a blank under your paragraph 19. There shouldn't be, but maybe that's just, I don't know. This is the part that's saying that, but for an attorney review period, it's binding, which is really important to understand, and for your specifically your sellers to understand that if they want to review it with someone other than you guys, this is the time. And then you guys have some information on here. Oh, you guys have that new buyer seller stuff. Yeah. Great. Okay.
Yeah, we put that on there, Kristen, so we could put in the percentage just to keep everybody on the same page of
I love it.
what, because some realtors you trust and some just like, okay, I'd rather confirm it, or verify it.
Well, and I had like some blind bids come in at one point with a Chautauqua property, and they had really moved that who was paying what commission around. And so
Yeah.
to compare offers, we had to do math a couple of different ways. So I really like this inclusion, and I love that they initial. That's
Yeah. Then one other thing, Kristen, I had to walk out for a minute, so I didn't hear about the closing date. But one thing I started putting on there lately, I know another company, they'll have a buyer sign a form stating that the closing date is, before you make any plans with movers or anything, confirm your closing date with your attorney, which is fine. But on the closing date, I started about a year ago. I always just put on or about, and then I make sure this way here people know, and they're not yelling at you when they have a moving truck outside and they're not closing that day.
well, the important language in that paragraph is that it says time is not of the essence, right? So without the declaration of it, it's not a binding date. But it does say right after the sentence stating what date, closing date, it says, or such other date as may be agreed upon by the parties hereto, and time is not of the essence. So those two things are where everybody can jump up and down and yell and scream, but unfortunately there's no liability.
I'll tell you a lot of that though. People don't look at that. They just look at the closing date, especially buyers and sellers.
I know.
They look at the closing date and that's it. That's why I like to just type it in there, on or about.
And we try to tell our buyers that too. Like we try and say like everybody's working toward that date, but it doesn't mean it is the date. So, I mean, just communication all the way through the process between all parties is best.
Okay.
Is there anything with regard to the first 3 pages of the contract that you guys want me to go through further?
So I just have a couple things. This is just something I heard, through the years. The address. So if I literally go up here, I mean, I have seen 123 Main Street. I've seen 123 Main Street, Jamestown, New York, 14701. So I assume full address. And then my second part of the question is, we should do, or you tell us the full address all throughout, the full address on the standard rider, the full address. So I mean, I kind of want you to is that?
Well, I'm a lawyer, so there's no such thing as overkill on wording. Like as much as you put in there, the better. The tax ID obviously is going to also clarify that, but yeah, absolutely. 1, 2, 3, and like what West Main Street or North Main Street, or you know what I mean? Like a lot of those indicators are advantageous as well. So and it also makes sure that we've got a lot of clients that have a lot of property. So it makes most sense to fill that out in its entirety.
Okay, perfect. And then Jim had a question, and I think we actually maybe answered it, but he asked if the buyer could invoke time is of the essence.
Absolutely.
So, yeah, okay. And so if you'll just take a second so the closing date is March 1st. either party says is of the essence. So just if you'll just take a second to just kind of clarify, like,
Sure.
I submit time of the essence, like what can happen, what does happen, whether we close on time or we don't, that kind of thing.
And it
So
seems like everybody's very resistant to issues. Time is of the essence. Why is that? They
I
they
think
hold
that, yeah, I think ultimately people want to go through with a contract that they've written. I think that's just the nature of humans ultimately. Um, but I think what's important, I'll address it from both sides. So as a purchaser declaring time is the essence, it's your out, right? The seller hasn't performed and what needs to be provided in order for you to complete the contract. So at some point you've got to say, we're done. We're done waiting on your title. We're done waiting on your lawyer. We're done waiting. We're done waiting. And so it's a 7-day declaration, regardless of what side you're on. It's 7 days. And a lot of buyers, it's less frequent on the buyer side to declare time is the essence. You certainly can, but it's more often declared by a seller for a purchaser who can't get a mortgage commitment or just isn't getting to the table. They chose a bank that's taking forever, whatever the situation is, and the seller wants to declare time is the essence. I tell my sellers, we can declare, and I'll tell you guys bold-faced, often as attorneys, we'll talk amongst each other and they'll be like, man, I can't get a commitment out of so-and-so and da-da-da-da-da. And be like, do you want me to shoot you a times of the essence letter? Because it pushes everybody, like everybody's done a bunch of work and this thing's going to get ruined. And so we can sometimes move a bank like that. Understanding when I tell my sellers, declaring time is of the essence, because you're declaring time is of the essence doesn't automatically terminate that contract. If in that 7-day window they go, we got it, we need 2 more days beyond your declaration, will you give it to us? The seller still has the opportunity to say okay and move through. So it is useful to kind of motivate a buyer, but the other part of it is they can then you're kind of letting them out of the contract to some extent as well. And you're ending up with the earnest deposit at best, because if you terminate the contract, there's no breach. So, if you have I think specific, when declaring time is the essence, it's very important that the attorney knows the specifics of the transaction and their client so that you can use it as the tool that it is to either terminate a contract in its entirety, understanding that it limits your seller to pursuing the buyer and for damages for breach. But it's a way to terminate a contract that's not performing ultimately.
Cool. Yeah. No, I appreciate that. That's good. Second question, and I know deal to deal can be different, but when we're writing these contracts and we have a mortgage commitment, then we pick a closing date. So if my mortgage commitment, and I talked to my buyer and the bank and we kind of know, hey, March 1st is the mortgage commitment. I don't know if I was told, I don't know. I always kind of just did 2 weeks after. So mortgage commitment for the first, close March 15th what should what should we do? What should we put on there to not press it,
Yeah.
to make sure we're not putting ourselves in a pickle right from the start.
I don't think that having a standard is going to serve you best, right? So saying a mortgage commitment is this day and then we go 2 weeks out, I don't think that's going to serve you in the best way. It is fairly standard to say 30 days from contract you'll have a mortgage commitment, but that's because the signing of the contract triggers the bank to start processing what's going on in 30 days is a reasonable time frame for a bank to issue a commitment off a contract that was signed 30 days ago. Closing really should be based on when your buyer is looking to close so that the seller can counter it's a term of the contract rather than just a date between, commitment to closing. That said, I really am going to speak a bit to practices by attorneys here, because there are some attorneys that represent sellers that won't even request a title search from their client. Furthermore, won't request an update on said title search until that mortgage contingency is met. And then you're way out of parameters for 2 weeks because, you know, I'll get a mortgage commitment in and send it over to another attorney and not get preliminary documents for review and title insurance, sometimes for a month or better, which is mind-boggling to me. But, you know, if then we're getting outside of the contract date and the seller can declare, and then your buyer's done all this work for nothing. You know what I mean? And then there's I will tell you that my office's standard procedure is to update title as soon as we even know someone's selling a house. I don't need a contract in order to get the title work started. They're probably going to sell it regardless. So, you know, we just kind of move through that process. But knowing the practice of the attorney representing the seller, at least to some extent, having a comfort level with what their turn time is helpful. I try to deliver preliminary documents to buyers' attorneys if I can the same day I get a mortgage commitment, just because it's a little game I play with myself, but as soon thereafter as possible, because it means, you know, they're approved all the way through to basically legal at that point, which the bank's waiting on title insurance, and we can get them all that stuff quicker if documents are delivered to the purchaser's attorney on mortgage commitment.
Hey, Kristin.
So that was long, but
one thing that it would be nice if it was incorporated in our contracts, but like a while back, I had a buyer that really wanted to close ASAP. And I told him, I said, one of the problems is updating the title search. I said, it's always slow. Everybody points to title companies. So he was willing to pay for it in the event the property did not close, but he wanted it ordered like ASAP. So we did. This was a while back. I don't really remember all the details, but I mean, that's something that we could have an addendum on if a buyer wants to close and they know that one of the delays is a title search, that the buyer is willing to pay for it in the event it doesn't close, and the proceeds can be taken out of his earnest deposit.
I'm going to tell you a couple of secrets here.
Yeah.
It's like a $50 charge if we cancel one of those. There's nothing major to it. There's no reason not to have it ordered. You know what I mean? So
I thought when you guys order, you're on the hook for that $700-800.
Nope.
Okay.
Well, that was well worth joining, knowing it's a $50 cancel fee. That's crazy. I was with Richard. I thought, you know,
Nope.
no wonder they're not going to order it. It's, you know, it's $1,000 or whatever. Oh my gosh.
Nope.
No, they can reverse it for 50
So
bucks.
if we do an addendum like that, can we edit the addendum, do you think, or would that irritate a lot of attorneys?
I think it irritates a lot of attorneys. But I'll tell you something. We're easy to irritate, first of all. Second of all, it's if you're sending it to me, we can find out what the status of the title is from the other attorney. I can probably tell you the status of the title just by who the attorney is. So it's just a matter of, again, that communication. This buyer wants to close quickly. Maybe you put in that attorney review period. Give me the opportunity to do a little homework on what the status of the title is. I have, on more than one occasion, said, hey, if you're cool with it, I'll just go ahead and order title as the buyer's attorney. Like I'll absorb the risk only because I know I can do things quickly. So sometimes it'll be like, my buyer wants to close within 30 days and the seller's attorney is whomever. And I'll call them and be like, hey, are you cool with me getting the title stuff done? I'll take it out of your seller's proceeds and pay for it. We all get the invoices. It's not like anybody's grabbing money out of anybody's pocket here. But if I've got an ability to get that done, or do you already have the search on that? Or it's really a conversation to see where the start point is, you know, because if it's one of my sellers, it's done here. Go for it. Run to the end of time. I don't mind. As a matter of fact, without a mortgage commitment, I don't mind forwarding the title for another colleague to review so that they can get ahead of the process and then order the title insurance with the mortgage commitment. It's not like they're going to keep my title in the event it doesn't go forward. You know what I mean? So there's strategic ways to kind of move these things, but it's really a matter of knowing what your start point is. I wouldn't really recommend reassigning cost because that's not going to move the ball. Does that make sense?
Yeah, we probably need the list of those attorneys. Have a no, I'm just kidding. I can't say
Well,
that.
I feel like you guys know some. And
Yeah.
I mean, a lot of it goes back to practices that well predate my participation. So like it was for me, it's the understanding of how the title companies work, what the risk is. And I mean, do I pay $50 cancellation fees every once in a while? I do. It's the cost of doing business. You know, I'm not going to lose sleep over them
For
or my
yeah,
practice.
honestly, for $50, they should order it day one.
I do.
Yeah, I think Kristen does. So good to know for
Absolutely.
anybody that has any sellers coming up that just want to close a deal seamlessly.
We get right on it because there's, like I said, it's more advantageous that I hit those closing dates. It's better for my practice, my reputation, my client happiness that I just hit those dates. But like I said, again, as a buyer's attorney, I don't have a problem talking to a seller's attorney and saying, "Hey, do you want me to get on this? I'll get it. Do you have a search? Do we need a 50-year order? You know, what's the starting point?" And then I know how to get there quickly.
Cool.
And
All right.
one other question I got to ask you about title searches. Why do most of the attorneys, and I don't know 100% why, but why do they favor sending the update title searches or the title searches to Chautauqua Abstract? Is it because the majority of them are partners in that business?
No, well, and none of us are partners. If anything, we're shareholders and some of us are directors, but we're not partners. We don't actually do
Okay.
anything with the functioning of it. And just for informational purposes, the dividends on those shares are very small. So there's not a huge like financial gain that would be motivating it. What does motivate it is they have the largest, what we call vault. So if I call them and, you know, Joe Smith has owned the property for 45 years and you want to close in 25 days, Chautauqua Abstract is probably the company that had the title when he got it 45 years ago. So the probability of them going into their vault and already having the start spot is higher than any other title company you're going to have around here because they're the oldest one. They have the most history.
Okay, so yeah, the reason I ask is because it seems like Chautauqua Abstract is the slowest, and it's always like, and why don't you send it to another company if they're so backed up?
Well, I'll tell you honestly, at the point that they were slow, everybody was wicked slow. Because even I tried to knock on some other doors, but I wasn't getting a different turn time. Whereas I do have a little more influence at Chautauqua, and you know, a collective group of us made
Okay, I
sure that
just
they heard
curious.
our yells. Where everything is back on track as far as time frame goes with that, though. Just so you know, there was some change in management, and searchers are hard to come by. So that pain was felt by all the companies. I don't think anything was turning quickly.
Okay.
Cool.
I don't
So
know if that
I have
clarifies.
one more question, and then I'll shut up and anyone else can answer. But so you, when you first started, obviously we're in Chautauqua County, but we're super close. You know, we all have done or probably will do a deal in Cattaraugus County, or you know, or even Erie County, because it's obviously it's not that far away. What should we be doing if we're going to do a sale in Cattaraugus County? I mean, I've used the Chautauqua County contract. Should we be using the Cattaraugus? You know, which contract should we be using if we do something in Cattaraugus County, for example?
I think anytime it's always best to use the bar association contract for the county that you're in. But I haven't had one attorney in any of those counties turn a contract around because it's on the wrong form. So, but what ends up happening is that your practitioners in those areas are most familiar with their own contract. So it's gonna go a little smoother through the legal process with the contract for that jurisdiction.
Makes sense. Makes sense. So I appreciate that.
Yeah.
So anyone else have, you know, so we went through the contract. Any questions on that? Certainly I mean, obviously we can open it up to, you know, any questions that we have. So I'm going to let anybody unmute themselves and ask away.
Yeah, what do you think about
what's your policy on handing out the keys?
On record,
Why?
bar rules.
What's the actual law in New York State?
It's not law in New York State. It's the rules of the attorneys in that jurisdiction. So we have Jamestown Bar Association rules, and it's on recording of the deed. The reason behind that is the assignment of liability. So the seller still has liability on the premises until such time as the deed has been filed. There's insurance over all of it. So I don't try and make people's lives difficult, right? A lot of times what we'll do to kind of ensure things, I'll get a call from somebody else's office saying, hey, everything's on its way to Mayville. If I drop a check off, will you release keys? I clear it with my clients. If they give me authorization, don't terminate your homeowner's insurance until I tell you to do so, right? Because that's what covers their liability. But ultimately, it's just a question in timing. New York State is a race notice state, which means that liability doesn't transfer from the seller until the deed is on record. But it's the rule is in the bar association rules as opposed to New York State law. A lot of things are practice, like stepping outside of real estate to make it a little more, as an example, each of our courts has its own rules too, right? So if you're practicing in Judge Cass's court, you have to follow Judge Cass's rules. And that's just the way it goes.
What about funds? So I had one where I was representing the seller and the seller's attorney told me I couldn't release the keys yet, but it was on record. They just hadn't received the funds from the buyer's attorney yet. So I was quite confused by that.
Yeah, so that's going to come down to, so now you're switching liability onto me as the attorney, right? So it's like, yeah, the liability of anything that happens on the premises is running with the title.
Sorry.
Oh, no, and if I release because the deed's been filed, but I haven't received funds yet, now it's kind of on my neck, So if it doesn't come through, I still have to comply with my seller, and I have to go back after that other attorney to resolve that. So that's a best practices question, attorney to attorney. And I'll tell you, you guys had referenced, like I trust some people, I don't trust others with regard to deposits and things like that. Comes down to that a lot. There's a lot of guys in this town that'll tell me, I'll have a check to you tomorrow, that's gold to me. Like we deal with each other's words all the time. There's others that I'm like, if it's $1 million, I feel a little different. If it's 20 grand, conveniences, right? Like, but it's going to come down to your attorney making that call with regard to funds, because they're going to have to make their client whole. That work? Okay.
You said Lakeshore requires a survey.
Mhm.
It's always a new survey. They won't take an existing with affidavit.
Correct.
Okay.
That's right. It's one that's a real pain too. So, because I have been caught in it myself, where we're like right up on closing, and it's like, well, we need the survey. The contract doesn't provide for one. Oh man, it's Lakeshore. You know what I mean? And then I got to call in a favor so that I don't end up with mud on my face.
And then it's when in that situation, the buyer ends up having to eat it. Yeah.
Yep. That's why. Well, it's not an eat thing. If the seller's not contractually obligated to provide it, and the buyer opts for a lender that requires it,
right?
It's their responsibility.
Because it's their lender. Not
That's right.
The sellers. Yeah.
They chose it. That's right.
That's probably why Lakeshore don't do a lot of mortgages, at least that I see.
They have a pretty heavy commercial portfolio around here.
Yeah.
Oh.
Mm-hmm. They do well commercially, and I think that's because they do everything by committees. Still, they do everything by committee, so it's helpful.
Anybody else have anything?
I did, but it's gone.
Oh,
I'll tell you a quick story about Lakeshore, Kristen. Years ago, back in '95, when we put this building up out back, Lakeshore, it was Lou. I can't remember his last name, but he was the manager and he gave us a commercial loan and they were very easy. And they were giving the money so easy. One time I joked with them. I said, man, I said, you guys give money out easier than parents would. And right after that, they gave us a hard time getting the balance of the money. I must have woke them up.
That I don't find them very hard to work with, residential or commercial, but it is worth note that that is the one local lender around here that will require a survey regardless of the terms of the contract.
That's good to know.
Oh, I know what it was. There's a surveyor, which we all know, that has on the bottom of his surveys now, not valid with an affidavit. So he's basically trying to get future business. He's saying this isn't a valid survey now as far as an affidavit and no change. That doesn't hold any water, really, does it?
Well, so what he's
It's a
actually
survey.
doing there is limiting his liability to a subsequent purchaser. There's nothing there. The instrument's already created, unless
Yeah.
you know what I mean. That the seller, the affidavit by the seller says there's no disputes with regard to those property lines and that they haven't changed anything that would alter the survey. So
That's the first I've heard of that, Jim.
Oh, really? Yeah, I
Yeah.
noticed. I was down at his office and he pointed it out, and I thought, well, he's trying to protect his income. He's just throwing it out there, basically. I'm sure some people fall for it. So
it doesn't really invalidate anything from our perspective.
right.
The instrument
Okay.
is the instrument.
Yeah, can't hate him for trying, I guess.
That I know that was a rough one on most of the surveying community, but I mean, I've also practiced or done something with regard to real estate in quite a few different jurisdictions. And New York's the only one that was heavy-handed, like on every transaction that it's resurveyed. It's in my opinion, it's a pretty heavy overkill, but who am I?
Yeah.
Well, if you go to Farm Credit in Mayville and you've got, a land and you want to go through them, they don't even require a survey.
They require very little.
Yeah.
Their whole purpose for being there is to kind of keep things available for our farmers. So
They require a pulse and 20%.
that's right.
And they have a little leeway on the pulse.
Right. That's true. That's true.
Awesome. Well, thank you so much, Kristin. This is great. If anyone has any questions, obviously, Kristin's available. If you have any folks coming up, looking for an attorney, I'm partial, but give her a try. So
I appreciate that. I'd like to, if I may, just a couple of quick notes.
yes, absolutely.
As a seller's agent, if somebody even asks you to list their house, start asking about a title search. It's a great place to start. The sooner we solve that puzzle, the faster they're going to get their money. And if you know you're listing, but you don't have a contract yet, and you can get your hands on a search and drop it off to the attorney they've chosen, you're ahead of the game. You're definitely ahead of the game. Well, in septics, if you know your client is listing and they are going to sell, those well and septic approvals through the county are good for 6 months. They're $350 or something like that, and you could save them an escrow. Of the last one I had to escrow for, the buyer's attorney wanted $20,000. Those are deal killers. So if you can get them to test while they're still in the property and while there's not snow on the ground, do it. It's definitely worth it. We've had contracts really slide in. I'm sorry?
That's good for 6 months?
Yes. Yep.
Unless it's a VA deal. The VA, man, they don't accept those. I think it was the well, not necessarily the septic, but if theirs is, I believe, 3 months. If that certificate's more than 3 months old, the VA will a lot of times raise a stink.
No, I haven't had that.
Yeah.
Noted. Yeah. Well, and the water test is the lesser of the tests. It's the
Right.
subject that we're really stressing over, right? The water test is like send them a new sample. It's like $30 for the second sample, and the county
And you
will
can
run
do
it.
it any time of the year, whether it's vacant,
Yeah.
occupied, anything. So
Right.
Yeah, the
yeah, but
water's
this,
not the problem. It's
Yeah.
That's
the
not the problem, it's a septic system.
Yeah.
Mhm.
Hey,
Yep.
Kristen, one last question for you on title searches. You know, when you close the, I've had deals closed before, and then the buyers call me in 3 months from now. They say, "Hey, I never got the title search from the attorney." Then I call the attorney. The attorney say, "Oh, it's at the abstract company." Why does it go back to the abstract company?
So the abstract company updates it and puts the rest of the setouts in. So when we file a deed and a mortgage, when the search comes back to us, now it's going to reflect that, and it's going to have the new owner on the cover. I will tell you though that sometimes when we get title insurance, or anything else that may be kind of hanging out there, release of lien of estate tax, or we've got to file that driveway agreement that's coming back, and there's an escrow between the attorneys, or things of that nature. I'm trying to think. School tax payments. Sometimes we have to update the title insurance company or the title company on the tax payments. So sometimes they'll hold them until all of that's collected and updated, and then send them back to us.
Okay.
But it always goes when we file. If there's title insurance, it goes with the title insurance order, and then they hold it until the filing. They bring it down and return it to us. So it's updated all the way through the filing of the deed. So when you pick up a title search from a seller, their search may only be updated through 1985, right? And so now they're selling, and so we update the search from 1985 to February 25th, 2025, we get the memo back. When we send the deed and all documents in for filing, they do another bring down right up to the time of the filing of that deed. And so once that deed goes on record, that's what that final bring down of the title search is going to reflect when it comes back. So they have the search in hand until they come all the way down to that final set out, which is that the deed and mortgage filed on that day. And then that's what date.
And typically, how long does that time take? I mean, because it was like 3 months, and the buyers called me. Does it take that long?
Not usually, unless there's title insurance that the final title policy isn't being issued until they get a signed resolution for filing, or something's hanging out there, and we all know it's hanging out there. And until they get that, they're not going to finalize the title insurance policy or finalize the search. But ultimately, they usually come back faster than that. What is relevant though in that conversation is that there's also an attorney practice in there that could be slowing it down, which is a lot of there are offices around here that hold searches. They don't even send them back to the buyers. So some buyers may be expecting them and then not ever get them.
Yeah. Do you hold them?
I do not. Heck no. But that's also a really good point with regard to the listings and talking to your sellers about where their search is. Because if they're like, what are you talking about? I don't even know what a title search is. I've never seen a title search. And you're like, well, it's a legal size book, usually has a blue cover or a cream cover, and it opens at the end. Like, you're describing the thing, and they're like, no clue what you're talking about. The next question is who represented you when you bought? Because if they have no idea where that search is, that's my next question. And then I know I'm going to hit Georgia up over at Pheasant and Lumber and D'Angelo because it's in their vault, so that's kind of continuing on that idea. But yeah, it should be coming back. There's no reason for it to be delayed like that. I usually tell people 8 weeks, like not to expect it from us for about 8 weeks.
Okay.
What if they tell you it was Kevin Serwaka?
Then I text Kevin.
And he has access to all that still?
Yeah.
Usually
and he's responsive. Yeah, I haven't had any trouble with getting wills or searches from Kevin at all.
Okay. And another thing you said, talk to your sellers, make sure they get their title search. If you're selling a wobbly box, a mobile home, very important, ask about your title or what other if it's earlier, what document do they need? If it's earlier than a 96.
They're not titled prior to 96.
Yeah.
We'll just do a bill of sale.
Okay. Yeah.
Yep. Mobile homes are fun.
Oh God. Yeah. They're a necessary evil, I guess.
Yeah. I mean, luckily we don't have a ton of them around here. So yeah, but that's definitely a good point is to start with that. Because if you have to get a duplicate, that's longer than a title search.
Mm-hmm. Yeah.
Yep.
And the data plate, because they've usually been remodeled and that got thrown out with the old cabinets or the, yeah.
Absolutely. Mm-hmm.
There is a place you can get that data plate too, but again, that takes more
Yeah.
time than the title search. So
It does. And usually we end up going back to the original dealers for that stuff, which is its
Right.
own monster.
yeah, if they're still around.
And that's exactly why it's its own monster. Yes.
Yeah.
Yep.
Yeah. Okay.
Awesome. Well, thank you everyone again. Thank you, Kristin. This has been great. Appreciate your time and all the info.
Yeah,
I'm
thanks,
happy to-
Kristin.
Yeah, of course. I'm happy to answer any questions. I think Wayne will tell you I'm not particular to answering, or I don't take offense to answering, general questions, even if I'm not representing. If you have a quick question and you just need clarification, please feel free to reach out. We're happy to help.
All right, thank you.
Awesome. Thank you so much. Take care.
No problem. Have a
Thank
good day.
you.
Too.